This video captures a highly intense and dramatic courtroom confrontation between a firm, no-nonsense judge and a defiant defendant, Mr. Jones, who insists on challenging the legal system at every step. Already serving time for armed robbery, Jones now faces an additional charge of assaulting a corrections officer, an offense that could significantly extend his time behind bars. Despite the seriousness of the situation, his attitude in court is anything but cooperative. From the very beginning, he appears dismissive, argumentative, and unwilling to respect courtroom procedures. What makes this case even more compelling is Jones's repeated insistence on representing himself. The judge carefully and repeatedly warns him about the risks involved, explaining that self-representation in a criminal trial is extremely difficult and that he will be expected to follow the same legal standards as a professional attorney. However, Jones refuses to listen, rejecting the assistance of his appointed counsel and pushing forward with confidence that seems misplaced. As the hearing unfolds, tensions continue to rise. Jones interrupts the judge, raises complaints about his treatment while in custody, and struggles to maintain proper courtroom behavior. The judge, maintaining control of the courtroom, tries to ensure that Jones fully understands the consequences of his decisions while also keeping the proceedings on track. This back and forth creates a gripping and unpredictable atmosphere, where every exchange feels more intense than the last. It becomes clear that this is not just a routine hearing, but a high-stakes legal battle shaped by one man's refusal to follow conventional legal advice, ultimately setting the stage for a trial that could determine the rest of his future.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what
Ms.
I
Martin
do.
does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now.
Tested.
I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent. With you asking questions and you're making a huge mistake.
Just add it to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay. There's the other problem. Because you are in custody, you have shackles on. Do you want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. You're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. Ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question. Are you aware of any? Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume, at
Correct.
least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand
Correct.
that?
Like impeaching a witness.
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yeah. Huh? No, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental. It will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay? But you understand what I'm telling you.
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Oh, can I get a few minutes? I use the bathroom anyways.
A few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do. I don't know how I'm supposed to, I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your security of this.
How I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
The officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
Yes, he was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself obviously is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen, because for the record, there's a skirt, or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. You want to again understand that this is not a license for you to abuse the dignity of this court?
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of.
All right.
Though.
Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
Why don't we do this? Why don't we do this, Mr. Jones? Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
I use the bathroom, please. I really gotta go, sir. I just need to use the bathroom. I'd be a lot more focused and stuff. I really gotta use the bathroom.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last
I
opportunity.
understand, sir.
All right. Take him, let's go off the record. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Ms. Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Ms. Martin
No,
to...
I don't want her near me, around me, or nothing. She can leave.
All right, sign the
She's good to
form
go.
in front of you.
What's the date?
Today's the 18th. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, you have, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need no
Mr.
help.
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason,
Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was
Okay,
the whole purpose of
she's
that.
not.
But she's still here and attached to my case. That's the
She's
whole
removing
purpose of
herself-
removing her was for that. Was for me to be able to represent myself.
You will be. Sign the form.
This
Read
form
it.
was already signed. You
All
already
right, read-
seen my
read-
signature. You already
I'm
asked
sorry, I
me my
misspoke.
signature. You see my signature was on that sheet. You already seen it was there.
Are you able to read and write?
Sometimes. Depends on how many pictures are on.
You done?
I ain't read it. I
get the
already
form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than that, are we ready
objecting to
to...
Ms. Martin is standing by
Mi-
counsel.
Mr. Jones, I'm going to tell you one...
Counsel.
Mr. Jones, I'm going to tell you
I'm not
what...
allowed to object. I'm my own counsel now. I'm allowed to objecting, ain't I?
Then you say the word objection.
I did. I said I object.
Yep.
How am I
What are you
supposed to say it?
objecting to?
I'm
I
objecting to
removed-
Ms.
I-
Martin stand by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her was and obtaining a conviction. My removing of her was
right, stop.
based on.
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
As the proceedings come to an end, the full weight of Mr. Jones's decisions becomes impossible to ignore. Throughout the hearing, he was given multiple opportunities to reconsider his approach, yet he chose to stand firm in representing himself, rejecting the guidance of his appointed counsel. His confrontational attitude, constant interruptions, and lack of courtroom discipline only made his situation more difficult. The judge, while patient, remained firm in ensuring that Jones clearly understood the risks he was taking and the consequences that could follow. What stands out most is how quickly confidence can turn into a disadvantage in a legal setting. Representing oneself in a serious criminal case requires deep knowledge of the law, strict adherence to procedure, and the ability to remain composed under pressure, qualities that Jones struggled to demonstrate. Instead of strengthening his position, his behavior often undermined it, creating tension and limiting any opportunity for a more favorable outcome. In the end, the result reflects not just the charges against him, but also the choices he made inside the courtroom. Additional time added to his sentence serves as a harsh reminder that the justice system is not something to challenge without preparation or understanding. This case leaves viewers with a lasting message. In high-stakes situations like this, respect for the process, willingness to listen, and making informed decisions can make all the difference. When those elements are ignored, the consequences can be serious, long-lasting, and impossible to reverse.